Hi, I'm Dan Sweeney, the Director of the Institute for Enterprise Ethics here at the Daniels College of Business on the campus of the University of Denver. We've been hearing a lot about something called conflict of interest in the business press and the general press over the past really several years. We usually read about it in terms of a major financial transaction or a major business decision that involves financial executives, business executives, attorneys, accountants, investment bankers, and so on. It's never really clear exactly what the conflict of interest might be, so we thought this might be a very good topic for the Institute to take up and to try to understand a little better. And fortunately, we have with us today John Holcomb, who is a professor of business ethics here in the faculty of the Business Ethics and Legal Studies Department. John has been writing and teaching about this for some 30 years, and that follows a distinguished career as the director of the Foundation for the Public Affairs Council in Washington, D.C. John, welcome. Thanks for joining us today.
Thank you, Dan. Good to be with you.
A good place to start might be very simply, what is a conflict of interest?
Dan, a conflict of interest is where a private or personal interest is in conflict with your official duty. And there could be different types of conflicts. The worst is that of a real conflict of interest. And then there are, beyond the actual real conflicts, you have potential conflicts of interest and apparent conflicts of interest. We talk about appearance of impropriety at times. And the appearance of a conflict is when a reasonable person would see that your conflict might jeopardize your independent judgment. We have different kinds of roles that we all fulfill. That would be our personal roles as individuals, our role as an organizational employee, our role as a member of a profession, whether it be law or accounting, and our role, of course, as a citizen. And any of those roles might collide. The quintessential example of a conflict is that of a whistleblower, where their basic personal interests in their job and in their income might collide with their duty to either their profession or, even more importantly, to the larger society.
Well, John, that was very helpful. I think we have a better understanding of the basic nature of what a conflict of interest is. But it might be helpful if you could give us some examples, maybe from the boardroom or from the senior executive suite, or just from the role of a regular employee.
Surely. Taking a look first, Dan, at a board member. If a board member is consulting to a competitor, obviously that's a real, actual conflict of interest and is completely to be avoided. If a board member is bundling political contributions to a political candidate who does not fall along with the interests of the firm, that of course could be a conflict of interest as well. And one that has happened in a number of companies is when a board member has an interest in a real estate company, either a family interest or his own, where he is either has property that has been sold to him by the real estate company, or he has an interest in the real estate transaction itself, and he brings a deal to the table of the board saying, why don't you buy this piece of property? Now, if that piece of property and that sales transaction happens to benefit him more personally than it does the company, or it's even at the sacrifice of the better interests of the company, then there's an actual conflict of interest by that board member. Would you like me to look at the executive as well?
Yes, please. You can think of a good example there.
Surely. If an executive is starting a firm that competes with the firm on whose board he sits, that is an actual conflict. There is a doctrine we talk about in terms of the duty of loyalty. If he usurps or she usurps a corporate opportunity by, let's say, spotting a potential deal down the line that the firm could take advantage of, and rather than disclose it to the board of directors, he decides to buy up that company or that supplier or whatever himself, that of course can be a real conflict. And another thing that sometimes happens for an executive is if they're hiring somebody who has a personal contact to him, either a personal relationship with that person, or he's even serving as a reference for that person. And obviously there may be a better candidate available and he winds up selecting the person with whom he has a personal relationship, then you have a direct conflict as well. And in terms of lower level employees, we even have the example, Dan, of the simple gift giving scenario, where if a lower level manager is trying to decide which contract to sign with a given purchaser, and he's making that decision, or she's making that decision, on the basis of gifts that they're getting from that supplier. That's going to skew the bidding process, and naturally they're going to then prefer the person who's giving them the gift, or might. And if they do, then that's an actual real conflict of interest as well. So you have a whole gamut of potential conflicts and real conflicts.
Mm-hmm. Those were good examples, John. That was very helpful. But it seems to me, with regard to the regular employee, don't most companies have rules of conduct and laws and regulations about taking gifts?
That's exactly right, Dan. They do. And they will prohibit gifts, especially above a certain amount of money, which might vary from company to company. But getting back to the influence that might be exerted on them through a gift, this, of course, is prohibited because there is a fear that even before they make a judgment as between bids and between contractors, that they might be unduly influenced by any gift they might have previously received.
John, you and I recently discussed an article that was in the New York Times within the past couple of weeks, written by Andrew Ross Sorkin, where he quoted the former vice chairman of J.P. Morgan as saying, "We're all totally conflicted, get used to it." Now, is conflict of interest really that widespread and that common?
Indeed, the conflicts are pervasive, Dan, and unfortunately, because people, especially at highest levels, are very interconnected in their business relationships, you find them very, very common. What you have to do then is to exercise due diligence in trying to avoid these conflicts, exercise due diligence in terms of appointing people to your board who might be more connected, and also inventory those relationships so you can figure out before you take a board position which are more prominent than others. And finally, if there are such connections, then you have to have independent checks and balances to monitor and try and control those conflicts.
John, are conflicts of interest always illegal?
Most of the time they are not, Dan. And those are the things we have to control through ethics codes. But there are different levels of illegality. First of all, if a director breaches a duty of loyalty to the firm. Secondly, if there's a failure to disclose conflicts and even potential conflicts to shareholders. And then thirdly, if there is an intent to actually defraud the company through these conflicts, then you have possible criminal liability.
John, you mentioned something about breach of loyalty as evidence of illegality. Can you say more about this loyalty issue?
Yes, Dan. Fundamentally, there are three basic duties that board members have. One is the duty of care, and one is the duty of loyalty, and then you have the duty of good faith. But very fundamental to their responsibilities are to be loyal to the firm, honoring confidential relationships that they have in terms of board conversations, and certainly not competing with the firm through other business relationships, such as consulting.
So John, even if a conflict of interest is not illegal, are they always wrong?
Often they are wrong, Dan, but not always. It could be that when there's a potential conflict, it actually turns out to be a convergence of interests, where the transaction may benefit both parties.
Well, John, could you say more about this convergence of interest? How does that work?
To give you an example, Dan, and going back to the board member who's bringing a real estate deal to the table for the board, if in fact that real estate deal not only helps the board member, but more importantly helps the company, that it's the best land deal that they can transact, then there might be a mutuality of interest or convergence rather than a conflict. Now that doesn't mean, of course, that if it's potential conflict to begin with, that it should not be disclosed to the board. It must be disclosed and perhaps discussed and then approved by the board in order to move forward, even if there's mutual benefit by both parties.
John, it seems to me that I remember reading about conflict of interest most often in terms of large, complicated financial services firms working on large, complicated financial transactions with a whole variety of partners and associates all involved at the same time. Why do conflicts of interest typically evolve in these kinds of circumstances?
The classic recent case that's most complicated, Dan, is that of two energy companies, El Paso and Kinder Morgan Energy Pipeline, merging. And El Paso was advised by the banker at Goldman Sachs Company. Now, Goldman Sachs had 19% interest, ownership interest in Kinder Morgan. They had two members on the Kinder Morgan board, and the banker himself had a $350,000 interest in Kinder Morgan. So when he is advising El Paso on this deal, he is really prone to represent and put forward the interests of Kinder Morgan, promote their interests over that of his client, and that is a blatant conflict of interest. The law firm Wachtell Lipton advised that this conflict was a real problem, and their advice was disregarded, so now you have a massive shareholder lawsuit in order to cure this conflict.
John, how can organizations and people avoid or remedy such conflicts of interest? I've heard of full disclosure, and I see it in these articles that although there was a conflict, it was fully disclosed. Is that a remedy?
Dan, disclosure may be a legal answer in some cases, but it's not totally an ethical answer. And it also addresses only potential conflicts. If you have a real conflict, then you want to recuse yourself from being involved in the decision, and recusal is simply you're absenting yourself or not taking part in the decision, or perhaps even resigning from the board of directors. And there's another way of approaching it, and that is, aside from recusing yourself, you could have an independent investigation or monitor to make sure that your personal interest did not affect your or undermine your official duty in that case.
John, I remember reading about something called a Chinese wall in these situations, where a large company will separate the two departments or two divisions that are working on a transaction so they don't share a common interest in the result. Are Chinese walls effective?
Dan, they are effective only in alleviating the problem, not eliminating it. Two stark examples. In the Enron Arthur Andersen case, you had Arthur Andersen operating as both a consultant and an auditor to the firm, and we found that however you might separate that, Sarbanes-Oxley said it was not adequate, and what you have to do is to make sure that the same firm cannot do both functions. So you disallow auditing firms from doing consulting. Elliot Spitzer looked at the other issue in terms of analysts, security analysts in investment banking firms, and his solution in out-of-court settlement was that these firms would have to separate the two divisions. But that is not adequate either, because an analyst who is advising a potential investor about a firm in which the investment banking firm is doing business, let's face it, they are all still working for the same company, and that company has an interest in boosting the value of the firms for which they're doing investment banking or underwriting.
John, in the New York Times article I referred to earlier, it seems like Andrew Ross Sorkin is accusing some corporate attorneys of turning a blind eye to this issue of conflict of interest. And he used a term called, quote, an appearance of a potential conflict, end quote. Now, what does he mean by that, and is that really a remedy?
To say that it's merely an apparent conflict, Dan, is to dismiss or to minimize the problem, because in all these cases, it turns out to be a real conflict. In the case of El Paso Energy and Kinder Morgan, Wachtell Lipton, the law firm which was giving advice in this case, actually behaved ethically and told them about the conflicts in the case and suggested the deal not go through, and they were overruled. Now, where the lawyers wind up giving them a pass is that in this case, Wachtell Lipton could have resigned as a further option. They did not. Virtually no law firm is going to resign because they have a financial interest of keeping these clients in tow.
John, this has been very helpful in us understanding the nature of conflicts of interest and how we might remedy them. In conclusion, I might ask you what kind of advice you would give to, say, an independent director on a corporate board, or a senior executive for a large corporation, or a consultant serving that organization. What would they best do to avoid such conflicts of interest?
Dan, I think the best thing they can do is to first inventory all their personal and their business relationships to ascertain which of those might cause any repeat problems in terms of conflicts with the decision-making of the board. And then to solve those, they can do one of two things. The first thing they probably should do is to step aside from some of those relationships, whether they be consulting or otherwise. And secondly, if they're financial relationships, they should put those into a blind trust, as many other legislators are advised or required to do, in order to eliminate any bias in their judgments. And furthermore, if they wanted to, they could also go to another member of the team, if they're a consultant, and simply pass over that business to the other consultant. And finally, they could even bring in an independent investigation to find out any conflicts which they have not been able to proceed themselves, so that they can then take the further steps to avoid those conflicts.
John, thank you very much for helping us understand the nature of conflicts of interest and how we might remedy them. And thank you very much for watching this video. We hope it was helpful to you as well.